Mike Brown, the former FEMA director.
Joining us here is the former FEMA director.
History, I think, was very unkind to you, my friend. Very unkind.
Mr. Brown, thanks for being with us.
This is Michael Brown Unplugged.
Welcome, everybody, to this episode of Michael Brown Unplugged. Glad to have you with me. I want to talk a little bit about what's called a 1001 in legal circles. When federal prosecutors, when they can't get enough evidence to bring charges against somebody suspected of a crime, they can still use a controversial law to get a conviction anyway. They charge the person with lying. And we've probably heard a lot about this in recent days, recent months, past couple of years, because of the perjury charges against Paul Manafort, against Lieutenant General Flynn, Martha Stewart a few years ago. She was she was prosecuted on charges of insider trading, but not found guilty. But she ended up going to prison anyway. And what did she go to prison for? She went to prison for lying to the FBI in their investigation about insider trading. That's why, let me just say this up front, that's why I say, and I think every lawyer worth his salt will tell you, never talk to law enforcement without a lawyer present. I don't care how difficult that may seem to do. If you are stopped and you are going to be subjected to arrest for almost anything, shut your mouth, refuse to answer any questions until you have a lawyer present. That is your constitutional right. And as much as cops may try to, hey, there's nothing to worry about, we know you didn't do anything wrong, we're just trying to, no, absolutely not. Their job is to get as much information out of you as possible. And you may be thinking to yourself, but I have nothing to hide, which that phrase, I want to strangle people when I hear that. You don't think you did anything wrong. You want to be cooperative. It's a tense situation where you've got a law enforcement officer, somebody with a gun, somebody that can arrest you, somebody that can imprison you temporarily. I mean, I get the strains of those kinds of situations. Don't talk to law enforcement. I remember as a kid, and my parents to this day probably still regret this to some degree, even though nothing came of it. But there was a bomb school called into a bomb threat called into my high school, and of course, bomb threat involves the FBI, and I was the student council president of the time, and I was known as a little bit of a troublemaker. I challenged authority. And so there was a knock at the door one day, and I answered the door because it was, as I recall, and of course, memories fade, memories change over time. But as I recall, it was late afternoon, and I was home by myself. And this FBI agent presented his credentials, asked if I was Mike Brown, and of course I answered yes. And he said he'd like to talk to me. Now, I made an assumption that it was about the bomb threat called into the school, because that was all the buzz. I mean, that was the entire buzz in town. And I had the wherewithal. I'm only laughing because it's like, okay, now we understand a little bit more about your background. We understand why you went to law school. We understand why you talk the way you do. We understand. I told this FBI agent that I'd be happy to talk to him, but I was not going to until my parents were home. My mom was out doing something. My dad usually didn't get home from work until, at least 6 p.m. So the FBI agent waited out front. Didn't bother me. He could have waited out there all night for all I cared. I wasn't going to talk to an FBI agent without my parents being present. And of course, when my mom finally showed up, she was like, well, no, you got to wait till my husband gets here, and we're not going to talk to you until everybody's here. Dad finally shows up. We have a conversation in the living room. And of course, I had nothing to hide. And of course, I didn't know anything about the bomb threat. All I knew was all the scuttlebutt at school, but I had the presence of mind to not offer any information. Well, do you know who did it? No. Do you know why they might have done it? No. I mean, I think my answer to everything other than am I Michael Brown, I may have answered yes to that. But everything about that bomb threat called into that school earlier that week, I don't think it was the same day, it'd take the FBI a while to get to my hometown. If there was a special agent in charge coming out of Oklahoma City, well, that's a 6-hour drive. If it's a special agent in charge in Amarillo, Texas, well, that's a 2-hour drive. Special agent in charge in Denver, well, that's a 6.5-hour drive. So yeah, my guess is it wasn't the same day, but it was a few days afterwards. But I didn't answer any questions. I still remember that because I think the mistake that we made, because this would have, I know it would have pissed off the FBI. Well, no, we're not going to talk to anybody until we have a lawyer here. They didn't do that. And in hindsight, I wish they had. Not because my answers would have changed at all, but the questions asked by the FBI agent, those would have been written down. Those would have been listened to by someone that could have said, well, I'm going to instruct my client not to answer that question because his answer, even though he may have done nothing wrong, might incriminate him. And so we're going to invoke his Fifth Amendment rights not to testify against himself, even though I may have not said anything that I thought was incriminating against me. But the law against lying, known in legal circles simply as a 1001, makes it a crime to knowingly make a material false statement in matters of federal jurisdiction. Now, critics on both sides of this issue argue that the 1001, a widely used statute in the Federal Criminal Code, is really wide open to abuse. And if we've been paying any attention to what's been going on in the news recently, I think you would fall on the side that says, yeah, a 1001 really is subject to abuse. It is charged hundreds of times every year if you look at the court records and interviews with lawyers and legal scholars. I want to give you just a couple of examples. And I'm going in the way back machine on these because I want old examples as opposed to current examples, because the current examples, General Flynn, Paul Manafort, for that matter, Martha Stewart, all of those cases are really infused with the politics of today. So I'm going to go back in time a little bit to give you a few maybe more politically neutral examples. And maybe you will come to the conclusion that, yeah, you don't want to talk to law enforcement without a lawyer present. Nancy Black. If it does mean something to you, it's probably the wrong Nancy Black. She's a marine biologist, and she was an operator of a whale-watching boat. She became ensnared by a 1001. Here's what happened. One of her boat captains whistled at a humpback whale that approached one of their boats. Regulators, now you talk about the deep state, you talk about the permanent bureaucracy, you talk about the administrative state. The administrative state decides to investigate her and her company about whether or not the incident constituted harassment of a whale, which of course is illegal. You can't harass whales. Did you know that? You go out the California coast to watch the whales. Don't whistle. No, don't whistle. In fact, you better have a digital camera that doesn't make any noise because the snapping of a film camera might be considered harassment. She was charged in the case, not with whale harassment, but with lying about the incident. And she faced a charge of illegally altering a video of the whale encounter, as well as a bunch of unrelated charges involving whale blubber. All of those charges carried up to 20 years in prison, and she denied all of the wrongdoing, including the lying. She says, quote, "I wasn't charged with anything about the dealings with the humpback, so why would they charge me with lying about it? It makes no sense." The Justice Department, of course, didn't talk about it at all. The law against lying, the 1001 that I'm referring to, is in section or in Title 18 of the United States Code. It's a bread and butter statute for the Justice Department prosecutors. The law is so broad that it makes it useful for nabbing wrongdoers, particularly in cases where suspected crimes are complex, they're tough to prove. But if you have that 1001 hanging over you, your lawyer may say, we've got a fantastic case against everything else. And if you want to go to trial, which, I always advise my clients to try to avoid trial at all costs, because that's really a roll of the dice. If you ask me even today, what are your chances at trial? If I think you've got the best defense ever, I would still tell you your chances at trial are 50-50 because you're rolling the dice. You're in front of a jury. You don't know how you don't know how the jury's going to look at you. You don't know what the jury's going to even think about you. And all of those intangibles, you may be handsome, you may be beautiful, you may be poised, you may be articulate, although that shouldn't make any difference because hopefully you don't take the stand in your own defense. But there are all those intangibles that take place in a courtroom, in a trial. And you have no control. You have no control over those intangibles once you walk into the courtroom and the trial starts. Your lawyer may just have a kind of appearance, attitude, or demeanor that turns off a jury. Be careful in the lawyer you pick. The law against lying, which you'll find in Title 18, Section 1001, that's why they're called 1001s, which is a reminder, footnote here. If you haven't done the exercise that I've asked you to do, which is to go to a local law school or a local law or library of some sort that has Title 18 or has the United States Code, particularly the United States Code annotated, I want you to look at the rows and rows of books that encompass the federal statutory code. And then ask that librarian to show you where the Code of Federal Regulations are. Those regulations which emanate from those statutes that the bureaucrats enact so that whistling at a whale might be considered harassment. Then tell me, yeah, I'll happily talk to the lawyers or law enforcement because I got nothing to hide. A fool, total fool. Now, supporters of 1001s, and I think this is legitimate, supporters of 1001s argue that the law can be useful in, for example, financial cases or SEC cases, because the prison sentence that you might face under a 1001 can actually be a powerful tool for getting that person's cooperation in unraveling the broader crime or the broader conspiracy. But the problem is, as the federal criminal code has grown increasingly large and complicated, critics on the left and the right argue that it's becoming too easy for Americans to unwittingly commit crimes. That's why I want you to go look at that code and then tell me, I got nothing to hide. Yeah, you do. You just don't realize it. I don't think anybody would argue that lying to Uncle Sam is either wise or admirable. But critics say that the 1001 is overly broad. I don't think there's a statute out there, in my opinion, that's more pernicious, because you can unwittingly, unknowingly violate this crime. It's the old trick of, and again, I don't use any current examples, but you can figure out kind of what I'm talking about here, where you interview a person one day and you interview them for, 8, 10, 12 hours. You wait a couple of days, you bring them back, or you bring them back the next day. Or you interview them for the morning, you take a long lunch break, and you come back and you interview in the afternoon, and you ask them the same questions, but you ask them in different ways. And because you're tired, you're not paying attention, you're not really sure, you answer differently. Well, were you telling the truth in the morning or the afternoon? Were you telling the truth on Monday or were you telling the truth on Thursday? The law is so vague. This is the point I want to make. The law is so vague that harmless misstatements can actually be turned into federal felonies. Because you see, a person can be charged even if the lie didn't really fool anybody, or even if you didn't know the criminal consequences of fibbing. If you aren't really sure, and you're kind of hem-hawing around, it's why I always told witnesses, clients, whatever, if you don't understand the question that the lawyer is asking you, ask them to explain the question. And I know that's hard to do on a witness stand, but I would really work with clients to don't be afraid to ask for an explanation. Don't be afraid to say, I don't understand the question. It's better for you to be able to clearly understand what they're asking so that you can truthfully answer that the answer is XYZ, or that you can truthfully answer that I don't know, and truthfully say, I don't know. The problem with the 1001 is that it can be a trap for innocent people to fall into. The statutes, the 1001's precursor, the False Claims Act of 1863, that law had a very narrow focus. It was intended to punish contractors and suppliers who were defrauding the government during the Civil War. But as I've said 1,000 times, what is the law or the intent today, when it comes to the government, always metastasizes and grows, so that over years, over decades, over a century, what was the original intent, now you can't even find that original intent. Let's go back to the False Claims Act of 1863, trying to nab contractors defrauding the government during the Civil War. Over the next 135 years, the Congress significantly increased the reach of federal law regarding falsehood so that by 1998, courts around the country carved out an exception known as the, quote, exculpatory no. That was aimed at blocking prosecution of a person who falsely denied being involved in any wrongdoing. The exception was at least partly inspired by the Constitution's protection under the Fifth Amendment against self-incrimination. But in 1998, the Supreme Court threw out the exculpatory no, saying that the law as written by Congress didn't allow for an exception. I agree. I don't agree with the impact. I agree with the court's decision. You know why? While some false statement prosecutions might seem harsh, Justice Scalia wrote that, quote, courts may not create their own limitations on legislation no matter how alluring the policy arguments for doing so. Justice Ginsburg, is she still alive? Anybody check her blood pressure today? In a separate opinion, worried about the extraordinary authority Congress, perhaps unwittingly, has conferred on prosecutors to manufacture crimes out of false statements. So many examples of why you should never talk to cops. Let's go back to Ms. Black, the marine biologist. She says that she considered the whistling unprofessional and told her employees not to do it. She says that the then wife of her boat captain went to the government to find out if there was anything wrong with whistling on the boat. The now former captain declined to comment, and his ex-wife wouldn't comment. But several days later, Mrs. Black says a federal official from the National Oceanic and Atmospheric Administration, part of the Department of Commerce, made an informal request, as opposed to a subpoena, for her to provide video of the whistling incident. She provided a video edited to show the captain's whistling because that is what she thought the investigators wanted to see. She didn't include she just didn't include the rest of the video that had been taken, where the crew members were egging on passengers to make noise. Now, the indictment against this woman who had altered the video, the indictment says she did it with the intent to impede the investigation of the whale incident and then falsely told authorities the video was the original recording when that recording had in fact been altered. Now, she acknowledged editing the video, but she denied that it was done to impede or kind of somehow block the probe. She denied lying about the video, and she pled not guilty to the charges. Then a year later, a dozen agents, led by a NOAA inspector, entered her house with a search warrant, took away her files, photos, and computers. And of course, over the 5-year period since the raid on her home, they questioned friends, colleagues. They questioned everybody. They made her life a living hell. She had paid more than $100,000 in legal defense fees. Here's an example of somebody who thought they didn't do anything wrong, that she had provided the government with the evidence and the materials that they wanted. And because she made that decision and made it without the advice of legal counsel, she got involved in litigation that lasted years and years and years and cost her hundreds of thousands of dollars. 1001s. 1001s are in the news. Now you know what they are. And now you know that what you need to make sure you do is you never talk to law enforcement without a lawyer present. Thanks so much for joining me today. Now, be sure and drop me a line if you'd like to comment about 1001s or this idea of lying to the government being a crime. You can always find me on Twitter at Michael Brown USA or on Facebook, facebook.com/Michael D. Brown. You can always follow the show at Michael Brown Unplugged. Now, if you haven't already done so, here I go. Don't listen closely. Don't forget to subscribe to Michael Brown Unplugged on Apple Podcasts, iHeart, Spreaker, Stitcher, Google Podcasts. You get the drift. Wherever you're listening to this right now, subscribe. And if you've been enjoying the show, if you've been enjoying these podcasts, I'd really appreciate it if you'd leave a 5-star rating and a review. Michael Brown Unplugged is written by me, Michael Brown, and produced by Right Turn Media. Marketing and social media is done by Whole Crowd. Thanks again for listening to Michael Brown Unplugged.